Okay, I think I'm going to start. So a good morning, everybody, and welcome to our live Q&A webinar on employment law updates with Stephenson Law, where we will be discussing the cases that have had the biggest impact for employers and HR professionals this year. My name is Julie Trunkfield, and I'm the Head of International Customer Experience here at Employment Hero, and I'm very much looking forward to today's webinar. As this is a live Q&A session, we've allocated time at the end of the webinar for your questions. Please do not hesitate to type your questions in the box down the bottom of your Zoom screens as we're going through the session, and then I will be reading them out and we'll get to as many of them as we can. I would also like to note that today's session is being recorded and will be made available as an on-demand webinar post-event. And then just a quick disclaimer, and we do recommend that you get expert advice if you feel you need it. So with that, I now have the pleasure of introducing our guest speaker for today, Fiona Campbell. Fiona is Interim Head of Employment and Senior Solicitor at Stephenson Law. With over 15 years of specialising in employment law, Fiona is a talented senior solicitor, well-versed in an array of matters impacting employers and employees alike. Working as part of Stephenson's Law employment team, Fiona balances a commercial approach with an empathetic underpinning, ensuring our clients are met with an extremely high standard of service at all times. And with that, I will now pass to Fiona to conduct the session. Over to you, Fiona.
Well, thank you. Thank you. That was incredibly kind. I wasn't really expecting that. So thank you very much. I feel a bit embarrassed. So today, as Julie said, we were going to be doing an overview of 2022. We'll be talking about significant employment law updates in 2022, which has been a bit of a tumultuous year. I'm sure you've all seen the flip-flopping on IR35 in the news. 1 minute it's going to be disappearing, the next minute it's back. And I know we had blogs ready to go and then, no, we're not sending them, then we are. And in the end, you know, you have to scrap it all. There's also been a lot of movement in particular discrimination cases and how the Equality Act has been interpreted. So we've got a lot to get through. So with that, we'll move straight into a bit of a deep dive into discrimination cases. Now, first of all, we're going to be covering the religion and belief area of discrimination. And possibly the most difficult and controversial topic is the one we're going to be covering first. So we'll get it out of the way. As you've probably seen, there's been a number of significant cases this year regarding the protected characteristic of religion or belief in the context of gender critical views. A number of people have brought employment cases against employers because of their belief that a person can't change their biological sex. There have been some significant complications in this area, not least because that protection then needs to be balanced against the protected characteristics of gender reassignment, sex, sexual orientation, and also, again, religion. So what I'll do is I'll give a bit of a brief overview about the relevant cases first, and then we'll discuss some of the learning points for HR and employers. So most of you might have heard about these cases because they were pretty well covered in the news and they're quite high profile. The first case involved Alison Bailey, who is a barrister, and she was the founder of the Lesbian, Gay and Bisexual Alliance group, which argues that there's a conflict between the rights of homosexual and bisexual people and transgender people. In the case she brought against Stonewall and her employer, Garden Court Chambers, she alleged that she lost work and income due to the Chamber's involvement with Stonewall's Diversity Champion scheme, which she said was exclusive and discriminatory of her beliefs. Now, I'm not going to go into lots of details of what the allegations were and all that kind of thing, because the important part for us is that the tribunal found that her belief was sufficient to be a protected belief. However, it was only an ET decision, so an ET decision isn't necessarily binding. But then there was another high-profile case along the same area, which was Forstater and CGD Europe and others. She acted as a visiting fellow for her employer. Ms. Forstater believed that a person's sex is a material reality that shouldn't be conflated with gender or gender identity. And she believed that a person's sex is an immutable biological fact, not a feeling or an identity. And most controversial potentially of all, she believed that a trans woman isn't in reality a woman. She engaged in debates on this topic on social media and made a number of statements in opposition to the government's proposed amendments to the Gender Recognition Act 2004. I'm not sure if you've heard about that, but there was potential that it was going to change so it would be easier for people to be recognised as the gender they identified with rather than the gender that they were had at birth. So some of her colleagues complained that they found her conduct offensive, and following an investigation, then her fellowship wasn't renewed. And she brought a claim regarding that. At a preliminary hearing, the Employment Tribunal concluded that her beliefs didn't qualify for protections. This was that as I'm sure you know, you often have preliminary hearings to deal with specific issues, like was a person disabled in order to actually be protected. And in this case, at the preliminary hearing, is deciding, did she have beliefs that could qualify for protection? And the Employment Tribunal concluded that they didn't. However, this was then overturned by the EAT, whose decision then is binding. So the EAT found that her beliefs were capable of protection, and they remitted the case to a freshly constituted tribunal to actually decide whether or not her claims of direct and indirect discrimination, victimisation and harassment could be made out. And the claims for direct discrimination and victimisation were upheld. But as I said, the main thing there was that the EAT again accepted that this was a belief that was capable of protection under the Equality Act. So the next case again is along the same lines, but all came about a bit differently, or came out a bit differently in the end. So in this next case, it was Higgs and Farmers School. So Mrs. Higgs is a Christian and was employed as a pastoral administrator and work experience manager by Farmers School. The school's head teacher received an email from someone outside of the school making a complaint about Mrs. Higgs due to her posting on social media with content that they believe was homophobic and about her beliefs that gender can't be fluid and that someone can't change their biological sex. Following an investigation and a disciplinary hearing, she was dismissed for gross misconduct for breaching the school's conduct policy, including in relation to discrimination and serious inappropriate use of social media. So she appealed against the dismissal, but that was unsuccessful. And then she brought a claim to the Employment Tribunal, saying she'd been directly discriminated against and harassed on the grounds of her religion, and that her following treatment, so there's following beliefs, had resulted in mistreatment. So there's a bit of a list of the things that she believed. So lack of belief in gender fluidity, lack of belief that someone can change their biological sex or gender, belief in marriage as a divinely instituted lifelong union between one man and one woman, lack of belief in same-sex marriage, opposition to sex and relationship education for primary school children, and a belief in the literal truth of the Bible. Now, the Employment Tribunal unanimously held that her beliefs that gender can't be fluid and that someone can't change their biological sex or gender were protected beliefs. So they followed along the same lines as those other cases. However, and this is a point now that is really useful for employers, they found that she hadn't been directly discriminated against or harassed because of those beliefs. What they found was that she'd been disciplined and dismissed because of the inflammatory language used in her Facebook posts, which could have led readers of those posts to believe she held homophobic or transphobic views. So it's a really interesting and important distinction that it was found that she wasn't discriminated against because she was dismissed, not because she held views that they found to be unpalatable potentially, but because of her conduct. And we've got another case then that sort of supported that. And this is the last case in this area. And the final case is Makareth and Department for Work and Pensions. In this case, Dr. Makareth was dismissed for refusing to refer to transgender service users by their chosen pronouns. He believed that a person can't change their sex or gender at will. He didn't believe in what he described as transgenderism and actually consciously objected to transgenderism. The EET found that these beliefs weren't capable of protection under the Equality Act, but that then went to the EAT. And the EAT found that the tribunal had erred in determining that they weren't capable of protection. In particular, they'd erred in holding that the beliefs weren't worthy of respect in a democratic society. The EAT held that the threshold had to be so low as to allow for the protection of not just beliefs that are acceptable to the majority of people, but also of minority beliefs that might actually go so far as to cause offence. However, the EAT also held that the tribunal hadn't erred in finding that the dismissal was fair and not discriminatory, because, and this is a bit like the previous case, it was permissible to draw a distinction between Dr. Makareth's beliefs and the way he manifested them. So it found that any employee who wasn't prepared to utilise service users' chosen pronouns would have been treated in the same way. So regardless of whether that was based on a particular belief or not, they would have been treated like that. Okay, so we've had a bit of an overview of the recent case law, but what do employers have to actually take away from this? Now, as we all know, employers are responsible for preventing discrimination and harassment at work and for promoting respectful workplaces that encourage diversity, equality and inclusion. So as I'm sure you're aware, it's been a significant challenge for employers over the years to balance the rights of individuals who have competing and often completely opposing beliefs. Even employers of the best of intentions can find themselves falling foul of litigation if they don't get this right. With this in mind, employers should be thinking about the following points to try and navigate the choppy waters of competing beliefs. So one protected characteristic can't trump another. So the Equality Act doesn't have a hierarchy of protected characteristics. Employers shouldn't be swayed by their own subjective beliefs. Any issues of discrimination should be assessed with appropriate legal principles in mind and then considered on their own merits. The next point I'd say is encourage a culture of openness, dignity and respect. So people can have conflicting views without their conduct becoming discriminatory or harassing. And it's a good idea for employers to encourage a culture where employees understand that a certain level of respectful debate is to be expected and is healthy, but it doesn't give anyone free rein to say anything they like. So everyone's got the right, as we know, to work in a place with dignity and respect, and employers should make it clear that discriminatory behaviour won't be tolerated. It's a fact of life that at times both employers and employees are going to have to tolerate views they don't agree with. But if you create an environment where people can talk openly about how they feel, but also then talk openly about their views, but then also talk openly about how other people's views make them feel, hopefully we can find a bit of a compromise situation. But also if someone is offended, you want to create a workplace where they can go to people, like maybe go to the line manager and say, look, I get that they don't agree with me and that's fine, but this kind of comment sort of starting to overstep the mark and really impacting how I feel at work. And ideally you want a manager who can deal with that. Now we all have grievance policies and disciplinary policies, but equally we all know that ideally is the last resort going to those points. What you prefer is that something can be dealt with in a more informal way, and communication is really, really the key with that. So as we've seen with the cases that I've mentioned on this point today, there's a crucial distinction between an employee's protected belief and the way they manifest that belief. So it's really important that we make the distinction between conduct and belief. If we've learned anything from these cases this year, it's that the distinction can be the difference between a claim for discrimination or harassment based on religion or belief being successful or failing. So employers need to be mindful, and HR personnel, of whether an action is taken because of the employee's protected belief or the way the belief was manifested. Employers are going to be in a much stronger position if they take care to only act in relation to a worker's conduct in manifesting their views, as opposed to the views themselves. By looking back at the cases we mentioned this morning, an employee is entitled to hold a gender critical ideology and should not be penalised for that. But if they refused in a workplace environment, say, to refer to a colleague by their chosen pronoun, this would most likely be inappropriate and could amount to harassment and could warrant disciplinary action. Unhelpfully, this distinction is not always obvious, and there have been a number of appeals lodged in recent times in relation to religion or belief. So I think we're going to have to just sort of watch this space on this one. Okay, moving on now to another religion or belief case, but hopefully a little bit less contentious, but looking at ethical veganism. So supporting the position that it is a belief, not conduct, that is protected, we're now moving on to, as I mentioned, this ethical veganism case. Now, we probably remember that a couple of years ago, an employment tribunal ruled that ethical veganism is a philosophical belief that is protected against discrimination. Ethical vegans, like dietary vegans, eat a plant-based diet, but ethical vegans also try to avoid contact with products derived from any form of animal exploitation. So that includes not wearing clothing made of wool or leather and not using product tested on animals. The employment judge had ruled that ethical veganism satisfied the tests required for it to be a philosophical belief protected under the Equality Act. For a belief to be protected, it must meet a series of tests, including being worthy of respect in a democratic society, not being incompatible with human dignity, and not conflicting with the fundamental rights of others. So this year, a case was brought which tested the limits of this type of protection. So in this case, it was 3 Miles and the Royal Veterinary College. I get my tongue tied around that, so I'll just say the RVC. So Ms. 3 Miles was a veterinary nurse. I see I'm still struggling with it. Anyway, who was employed by the RVC. In February 2019, she was actually arrested by police in connection with alleged burglaries by the Animal Liberation Front. The police also found a sick turkey at her flat that she said she'd rescued. Following her arrest, she was then summarily dismissed by RVC for reasons including the fact that RVC believed she was connected with an animal rights group that endorsed law breaking and that she had participated in activities including trespass and theft. She brought an employment tribunal claim against RVC for, among other things, direct and indirect philosophical belief discrimination. She relied on her belief in ethical veganism and arguing that the belief included a moral obligation to take positive action to reduce animal suffering, including trespass on property and removal of animals. By the time of the tribunal hearing, she'd actually been charged by the police with criminal offences relating to animal rights activities. So the ET found that belief in ethical veganism, encompassing an obligation to break the law to relieve animal suffering, did not amount to a philosophical belief. The tribunal stated that had her belief in ethical veganism been limited to the belief that humans should not eat, wear, use for sport, experiment on or profit from animals, it would have had no reservation in concluding that it amounted to a philosophical belief. It also went on to say that it might have reached the same conclusion had the moral obligation to take positive action to reduce or prevent animal suffering been limited to lawful action. However, her belief included trespassing on private property and acting in contravention of the law. So the tribunal concluded that belief to take actions that are unlawful and interfere with the property rights of others could not be worthy of respect in a democratic society. In an employment context, regardless of what the belief relates to, an employee is not going to be entitled to use this as an argument for obstructive or destructive behaviour. So they're not going to be able to say, well, it's my belief that allows me to do this. That would not then be capable of protection. So I think this is my last case that I'm going to chat about religion and belief, and it's a little bit of light relief in the middle of our presentation this morning. And it's one that I think is going to make employers and HR personnel everywhere breathe a bit of a sigh of relief. So this case is called McClung and Dusan Babcock, and it's a very useful case for employers in terms of limiting the philosophical belief element. But this case is very topical because it relates to football, and obviously, as we know, the World Cup is going on at the moment. So this case was actually heard in the Glasgow Employment Tribunal and was brought by Mr. McClung. He was a Rangers supporter and he had been for 42 years. He was a member of the club. He received birthday cards from them. He never missed a match. And he spent most of his disposable income on going to see matches, paraphernalia, everything sort of Rangers related. And he believed that supporting Rangers was a way of life, and as important to him as attending church is for people who were religious. The Employment Tribunal held that supporting Rangers Football Club didn't amount to a protected belief under the Equality Act. So reliefs all around everybody. The tribunal considered the explanatory notes. Now, I don't know whoever else considers the explanatory notes of the Equality Act, but anyway, they considered the explanatory notes, which provide that adherence to a football team would not be a belief capable of protection. The definition of support being actively interested in and concerned for the success of a particular sports team, contrasted with the definition of belief, which was an acceptance that something exists or is true, especially something without proof. Mr. McClung's support for Rangers was more seen as akin to support for a political party. And as you may already be aware, case laws made clear that that does not constitute a protected philosophical belief. So support for a football club is more seen as a lifestyle choice. It does not represent a belief as weighty to a weighty or substantial aspect of human life and has no larger consequences for humanity as a whole. Very, I think, interestingly, and also contrasts with the previous veganism, not the one we just discussed, but the older veganism case, was the fact that there's a wide range of Ranger fans with varying reasons for the support, and that's the case of all sort of football teams. There was nothing to suggest that fans had to behave, or in fact did behave in a similar way. Now, Mr. McClung's position was that part of being a Rangers fan was about support for the unions, the United Kingdom and Scotland being part of the union, and loyalty to the Queen. However, they're not prerequisites for being a Rangers supporter. The only actual common factor for all Rangers supporters was they wanted their team to do well. So there wasn't the cogency, cohesion and sort of importance that's required in order to be a philosophical belief. So previously, going back to the veganism cases, what they previously found was there's enough of a kind of sane belief, if you're an ethical vegan, how you did that. It was cogent enough that it could be protected. But in the case of football teams, there just isn't, because you can do it in so many different ways. In addition, support for a particular football team doesn't invoke the same respect in democratic society as matters such as ethical veganism. So as I said before, a little bit of light relief there at the end of our belief cases, religion belief cases. But I definitely think that everyone could be, breathing a bit of a sigh of relief, because imagine the disaster if it was actually considered a protected belief. So I live up north, and I just think of all the employers out there with their contrasting Newcastle and Sunderland supporters. It would just be an utter disaster. But anyway, so you can breathe a bit easier now. And now I think we'll be doing our last discrimination case, and we're moving on from religion and belief, and we're going to discuss a couple more topics that are particularly on disability discrimination, and in particular relating to long COVID. So this year, in the case of Burke and Turning Point Scotland, Mr. Burke was employed by Turning Point as a caretaker from April 2001. In November 2020, so the dates are a bit important here, but in November 2020, he tested positive for COVID-19. Initially, he had fairly mild symptoms. However, he developed severe headaches and fatigue, and things like after walking, showering, dressing, he had to lie down to recover and struggled standing for long periods. He couldn't undertake household activities like cooking, ironing, shopping. He experienced joint pain, loss of appetite, a reduced ability to concentrate, and difficulty sleeping. He also felt unable to socialise. So the symptoms were unpredictable. He would experience improvement for a while, but only then to suffer from a fatigue and exhaustion again. From January 2022, his health did improve. However, sleep disruption and fatigue continued to affect him. But anyway, looking back, so he remained off work. So he'd initially gone off after he was diagnosed in November 2020, and he remained off work from November 2020. Now, the fit notes were all a bit, a little bit sort of random. They didn't all necessarily say the same things, but in particular, later fit notes referred to the effects of long COVID and post-viral fatigue syndrome. But in contrast to those fit notes, A couple of occupational health reports stated he was fit to return to work and that the disability provisions of the Equality Act were unlikely to apply. However, relapses of his symptoms, in particular the fatigue that impacted him a lot, meant that he didn't actually end up returning to work. He was then dismissed in August 2021 because of ill health and it brought a disability discrimination claim. Now, the dates are important. So he initially went off in November 2020 and he was still off and was then dismissed in August 2021. As a preliminary issue, a tribunal had to determine whether he was disabled during the relevant period. So as I'm sure you'll be aware, in order for something to amount to a disability for the purposes of the Equality Act, the condition needs to be a physical or mental impairment that has a substantial and long-term adverse effect on your ability to undertake day-to-day activities. And it concluded that he was. It considered that he wasn't exaggerating his symptoms and he had a physical impairment. Now, the lack of particularization within initial fit notes, so it's all a bit vague, they said could be explained by the restrictions on in-person consultations at the time. So obviously during the different lockdowns. His fluctuating symptoms were actually consistent with a report from the TUC in 2021. The physical impairment was found to have an adverse effect on his ability to carry out normal day-to-day activities. The effect was also found to be more than minor or trivial and long-term, because it could well be that it would last for a period of 12 months when viewed with the dismissal date. So bear in mind that it started in November 2020, was dismissed in August 2021. So it would only need, so that's 9 months, I think. It would only need like another 3 months of lasting another 3 months, and it would have that over 12 months. The tribunal also noted that the employer's own view that there was no date when a return to work seemed likely. Now, this feels like one of these catch-22. Anyway, I've suddenly lost my numbers. Anyway, it's one of those. And because basically, as you know, in order for the employer to be able to fairly dismiss someone for long-term absence, they need to sort of reasonably think the person's not going to be coming back soon. If they thought he was coming back in a couple of weeks, then it wouldn't be fair for them to dismiss him. But the very fact that they've, after 9 months of absence, have said, look, we don't know when he's going to be coming back, also suggested it was a long-term condition. So it actually supported his position that he was disabled, but it didn't necessarily, you know, but it did also support potentially their decision that it was reasonable for them to dismiss him. But for the purposes of, is he disabled, them actually finding that kind of supported his case. So the Burt case then established that long COVID could indeed amount to a disability under the Equality Act. So employers certainly do need to bear this in mind. However, equally, just because someone has had COVID, we shouldn't automatically assume that it's going to fall within the definition of disability, or that it's a carte blanche for an employee to win a disability discrimination claim. So this is supported in the next case that I'm going to talk about, which is our last discrimination case. In the case of Quinn and Senn Scotland, Mrs. Quinn was employed as a head of people. She tested positive for COVID on or around the 11th of July 2021. She subsequently experienced fatigue, shortness of breath, pain and discomfort, headaches and brain fog. These symptoms affected her everyday life and disrupted her sleep. She struggled with shopping and driving and stopped socialising and exercising. So, and then on 26th of July, so that's like 15 days later, she contacted her GP to arrange an appointment. On 27th of July, she was dismissed from her employment. So my maths is shocking, but I think that's like 16 days after being diagnosed on the 11th of July, she was then dismissed on the 27th. She consulted with her GP on the 2nd, 8th and 22nd of August, and during all that time, she was still deemed unfit to work due to ongoing symptomatic COVID. On the 12th of September, she was deemed unfit to work due to post-COVID syndrome and diagnosed with long COVID. So 12th of September is the first time she was actually diagnosed with long COVID. She brought a direct disability discrimination claim, among other claims. And as a preliminary issue, the tribunal had to decide whether she was disabled at the time of her dismissal. So, a lucky one for employers here, because they found that she wasn't disabled under the Equality Act for the following reasons. At the time of the dismissal, she didn't have long COVID. She wasn't actually diagnosed with long COVID until about 6 weeks after being dismissed. While the impairment of COVID had a substantial adverse effect on her ability to carry out normal day-to-day activities, the effect had lasted only 2.5 weeks at the time she was dismissed. And so at the point when she was dismissed, wasn't viewed as long-term. And finally, the substantial majority of people who catch COVID don't actually develop long COVID. So it can't really be said that the risk of developing COVID could well happen. So at the point of dismissal, basically what the tribunal's saying is the employer both didn't know that she had a disability, but couldn't have reasonably been aware that she could possibly have a disability, because at the point when they dismissed her, all they knew was that she had regular COVID, and it wasn't reasonable for them to sort of think that would potentially develop into an actual disability. Now, obviously, the two cases are a bit contrasting, but it was found that the second case, so the Quinn case, could be distinguished from the Burke case, because his absence had been for 9 months at the time of dismissal, and it had been for long COVID and established it was long COVID. And as we said, the employer had even accepted that it was likely to last indefinitely. So the takeaway, therefore, is that while the effects of COVID could potentially amount to a disability, don't panic. Each case should be considered on its own set of symptoms, and if in doubt, do take advice in this area. So if you're a bit concerned about dismissal in this area, definitely take advice. So we're going to leave discrimination now and move on to our general update, so our general cases. We've got a few cases that we're going to go through here before we then move on to things to watch out for in the future. So first of all, we're going to discuss settlement agreements, and specifically the fact that a recent EAT decision has confirmed that you've got the case name there, I think. So if you are interested and want to look it up, but the facts aren't particularly exciting. But in this case, the EAT decision confirmed that a settlement agreement can't sign away claims which have not arisen at the date of the agreement. In addition to this, the EAT also commented on the scope of settlement agreements and the practice of listing a series of claims to be settled. Now, we probably all do this. So again, what I'm going to say is wait, don't panic. But I know when I draft settlement agreements, there's generally that clause in it that says, you know, you're settling all and any claims, whether or not you could have known about them at the time. And then at the end, you've got a list of any imaginable claim. You know, you've got fixed, no claim for being treated less fairly because you're on a fixed term contract, even when the person's never been on one. So that's what this relates to, basically. The EAT said that references in earlier case law to potential claims being capable of settlement meant claims that are known to the parties, but not actually brought to the tribunal. So it was the EAT's view that settlement agreements shouldn't simply list a variety of possible claims by reference to their nature or section number, because this is essentially an attempt to disguise a general waiver of claims, which is saying you shouldn't really be just generally waiving everything. If there are genuinely multiple complaints, and there's nothing wrong with seeking to settle them through an itemised list, but the EAT's point was concerned the practice of seeking to waive every imaginable claim, whether it was relevant or not. The comments of the EAT weren't strictly related to the facts of the case, so they're not binding on future tribunals, but they're nonetheless interesting and likely to be persuasive. It'd probably be wise for employees to be a bit more selective when we're adding the lists of claims. So like I said, you know, if you know this person's never been on a fixed term contract, maybe delete that bit. You know, if you know that they've been paid 90 grand a year, don't have claims relating to minimum wage. However, while the case is useful and we need to be mindful of it, in reality, it's only very unusual circumstances where this is actually going to be relevant. So that's really situations where you've settled your case, but then something comes out of the blue. So something you weren't aware of, or the employee wasn't aware of. So for instance, they found out that there's been an email chain saying that they've got to be made redundant because of their age, and they find this out. And before that, they had no idea of it. Then it's possible that the tribunal would say, well, they couldn't settle any age-related age discrimination cases because they had absolutely no knowledge this was an issue. But this doesn't mean that all your settlement agreements, if it includes too long a list, are going to be sort of invalid. In my experience, the vast majority of situations where using settlement agreements in practice, you know, are pretty simple, really. The employee wants some money and the employer doesn't want a claim to be brought, and they want the employee or the claimant to be gone. And once the employee's got their money, it's going to be really very rare that they want to do anything that might jeopardize them being able to actually keep that money. So what I would say going forward is, yes, this is an important case. We can see that, I mean, personally, I always felt it was a bit iffy. You always have this clause saying you're settling all and everything. But really, I would always advise clients, look, this is normal to have this in here, but it's unlikely to be enforceable. Well, that's kind of been supported with this case, that it is unlikely that you can settle things that aren't really in the minds at the time. But it's really rare that that's going to be an issue. So maybe be a little bit more selective in your list of claims, and be aware that, you know, if something absolutely new came to light, you can't necessarily rely on the settlement agreement that you've got in place that really related to a completely different set of facts. Okay, the next case we're going to talk about a bit is redundancy. So unfortunately, this is a bit of a topical thing at the moment with the economic uncertainty that we're all going through, and it's causing some employers to reduce their headcounts. So a recent EAT decision is a reminder of the importance of carrying out meaningful redundancy consultations and the risks associated with using potentially a single selection criteria, which I have to say I would always advise people against. In this case, a nurse was employed on a series of one-year fixed-term contracts, and her employer selected her redundancy because her fixed-term contract was due to expire before that of another colleague. So everything else was the same, but they said, right, because yours is going to expire first, you're gone. So the end of her contract was the sole criterion for selection, and there was no prior consultation. Now, personally, I know that best practice is to consult with staff on the criteria you're going to use for selection. But a lot of cases, my clients don't really want to do that, because you can imagine a situation where you've got 10 employees and you only say you've got 10 people doing the same thing, and you just want to reduce them by like 2. So you want to get it down to 8. You don't necessarily want to put into panic, you know, put all 10 absolutely panicked and tell them all and get them all involved in this sort of consultation process, when actually ultimately it's only going to affect 2. Also, I feel that consulting on the criteria, it's not really very effective in most cases, because everyone can assess themselves, and you're going to pretty quickly realise that if this is the criteria, I'm either not going to be at risk or I am going to be at risk, and those who are going to really argue against that criteria. So personally, I would normally say get your criteria sort of sorted and find out who's score people, find out who's at risk, and then start consulting. I appreciate generally it's not best practice, but I do think that sometimes you need to figure out what's going to be the best thing for the business. Now, sort of moving on with this case again, there's my little bit of tuppence worth there. But whereas an employee's got the right not to be unfairly dismissed for reason of redundancy, individual consultation is absolutely fundamental to the fairness of a redundancy process, regardless if you've had collective consultation. So consultation has to be genuine and meaningful, and it needs to start early enough in the process to actually have a meaningful effect on the outcome. So in this case, the issue was that because you had this one criterion, because they'd not consulted on it, but as soon as she was then put at risk, or as soon as they told her, well, we've only got this one criteria, and so you're going to go, it was found that, well, they couldn't effectively consult with her because that was the only thing, and they'd already decided it. So it was a bit of a fait accompli, whatever. It was already decided as soon as they started consulting with her, because they'd only used this one criteria. Now, it's not going to automatically be unfair to use a single criteria, but it would need to be objective, non-discriminatory, applied fairly and consistently. And there should be a good reason for only having this one. And in this case, it wasn't particularly like, what impact was that going to have on the service going forward or anything like that. But where possible, it's definitely best practice for employers to use several criteria. And finally, just one other point to be aware of, a blanket policy of making, say, fixed-term employees redundant before permanent staff could be in breach of the fixed-term employees regulations, and there's no minimum service requirement for that. So it could also lead to unfair dismissal claims for fixed-term employees with more than 2 years service. Okay, the next case, so this is the final thing for the case law updates before we move on to what to look out for. We're going to look at a recent case that considered employment status. I can almost hear the boredom, the waves of boredom. Another case about employment status. We've had all these Uber cases, we've had all that. Yes, there's another one about employment status. This one related to the intention of the parties. Again, I'm not going to go into details about the facts of the case because they're all a bit tedious when it comes to employment status. However, the question here was whether the party's intention as to employment status was capable of being determinative. And the EET here held that no, the intention of the party, so just because you say either they're employee or they're self-employed, that won't, so just because you both agree that's what you wanted at the time when you create the relationship, that isn't going to in and of itself be determinative. The Employment Tribunal held that the claimant was self-employed on the basis that a self-employed relationship was the true intention of the parties. But the claimant then appealed, and the EAT decided that the tribunal had actually put too much emphasis on the party's intention rather than looking at it as just one factor to be considered. And we know there's a whole balance of factors that need to be taken into account when deciding on someone's employment status. The EAT said that this case wasn't so finely balanced that the intention of the parties could be considered to be the tipping point. So if it was all things being equal, you could say, well, okay, finally, it's really, really finely balanced. So what did both people want in the first instance? So this case is a good reminder that no one factor is determinative when considering employment status, and also that tribunals will look at the relationship as a whole. Finally, it also reminds us that what's in the written contract will not necessarily sway a tribunal if it doesn't actually reflect reality of what the genuine relationship or the working arrangements are. I have to say, I do get this all the time, that people want you to produce a contract that's going to be cast iron, but it's like, well, I can put anything in here, but if it doesn't really reflect what you're really doing and how you work together, it's not going to help really. I mean, you know, it's important that you're clear, but it won't be completely decisive. So finally, we're now going to have a quick run through of a few things to watch out for in the coming months and next year, so moving into 2023. So first of all, there's the retained EU law bill. So back in September, the government published its retained EU law, revocation and reform bill, snappy title, in the House of Commons. The bill has created a presumption that all EU-derived laws will be removed from domestic law at the end of 2023, unless specifically saved. So important point there. It's a bit difficult at the moment to comment on the bill because it's created quite a lot of uncertainty. To be honest, I think it's unlikely that it's going to result in a wholesale removal of EU-derived employment rights, because some of them are just so ingrained. But it is possible that it will result in a downgrade of workers' rights. So it's not impossible. Some things I think, like, you know, people are going to be in panic about reducing holiday. I'd be surprised, because we've actually gone beyond what the EU law was regarding things like holiday anyway. So I'd be quite surprised. The kinds of laws that we could see affected are working time and paid holiday, although, like I said, I think that's unlikely. 2P, although I'm not sure many people would be sad to see 2P getting changed. I'd be one of them, and I think most employment lawyers, but also part-time and fixed-term workers' rights and agency workers' rights. Unfortunately, the uncertainty around this does mean that employers need to keep a bit of an eye out for any announcements on this next year. At the moment, we don't know what's going to happen, and it could be that there's a sudden and drastic upheaval of employment law, no change at all, or something in between. So watch this space. Next thing I want to chat about is menopause in the workplace. So this year, the government responded to a report commissioned by the Minister for Employment about menopause and employment. In its response, the government stated that it doesn't believe that there are any changes needed to the Equality Act to further protect people going through the menopause at work. Essentially, the government concluded that the existing protections under the Equality Act provide adequate protection against unlawful treatment. So I'm assuming that sex discrimination, age discrimination, and potentially disability discrimination. However, unsurprisingly, the Women Equalities Committee, which had published a separate report on this, took a different stance. Two of the committee's key recommendations are for the government to enact Section 14 of the Equality Act, which protects against multiple discrimination, i.e. discrimination related to a combination of two protected characteristics, so say sex and age here. And to add a new protected characteristic under the Equality Act to give specific protection related to menopause, including a duty to make reasonable adjustments for employees experiencing menopause. And we haven't had a government response to that yet. So while these reports and the government's response don't tell us much about what's going to happen regarding menopause in the workplace, it's definitely a topic that's got people talking, and I know we've had queries about it. So employees should take care to ensure they're supporting employees experiencing the menopause and keep an eye out for possible future changes to the Equality Act. So finally, government support for private members' bills. The government's recently announced support in second readings for a number of private members' bills. It's not a guarantee, but does increase the likelihood of proposals coming into force in the next year or two. So the bills that have received some support include the Worker Protection Amendment of Equality Act bill. This is the introduction of employer liability for harassment of employees by third parties, and a new proactive duty to take all reasonable steps to prevent sexual harassment in the workplace. This could also have a potential 25% uplift for any awards if it's found to be breached. The Employment Relations Flexible Working Bill, which is changes to the right to request flexible working to allow 2 requests for 12 months. At the moment, it's only 1, and require employers to consult before refusing a request, which you should do really anyway, or would be good practice in any event, and to make decisions within 2 rather than 3 months, and remove the requirement that the employee has to explain in the statutory request what effect the change would have on the employer and how that might be dealt with, which does always seem a bit onerous because the employees may not really know or understand how their flexible working request might actually affect the business. Protection from Redundancy, Pregnancy and Family Leave Bill. So this bill would extend the redundancy protection, requiring employers to offer suitable alternative vacancies to an employee on maternity, adoption or shared parental leave to cover periods during or after pregnancy, including after early miscarriage or after maternity, adoption or shared parental leave. And finally, the Carers Leave Bill, which would be a day 1 right with certain caring responsibilities to unpaid leave of 1 week per year, which could be taken in half for individual days and wouldn't require evidence of entitlement. So as I mentioned, the fact that these bills have received support doesn't mean they will definitely become law, but it can give an idea about the way the wind's sort of blowing when it comes to employment law changes. So that was a bit of a quick fire. I feel like I've sped through that, so I hope you've managed to grasp most of what I've gone over. But now I think we've got hopefully about 10 minutes left for some questions.
We do. Thank you, Fiona. Some really interesting and thought-provoking situations there. So we do have some questions come in. So I'm going to start with a question from Rachel. What is the best way for an employer to make the distinction between conduct and belief? i.e., should the employer provide training or a policy on this topic, e.g. the Higgs case?
Yeah, well, that's an excellent question, because I think sometimes it's going to be quite difficult, isn't it, to establish, I think, when someone's just sort of expressing their belief and when it goes on to impact others. And I think it's often going to depend on the circumstances. So some people are maybe going to enjoy a debate a bit more than others. And I think it's going to be, to start with, as we mentioned, having this sort of open culture where people can discuss and talk about how they feel about these discussions. And if someone is saying, look, this makes me feel uncomfortable, then I'd say at that point, going back to that person saying, look, I understand and you're entitled to your beliefs, but at the moment, the way that you're acting on that is now starting to cause issues. And at that point, I think if they then kept going with it, you would maybe be like, right, now it's not to do with your belief, it's the fact that we've kind of said that you need to sort of tone it back a bit, or you need to be careful how you express your belief. And you've continued to express that belief in a way that's making someone else someone else uncomfortable. So it's not that you believe that, and it's not that you're expressing that, but we've now sort of said you're making your colleague uncomfortable. So if you continue to go along that route, you'd maybe be able to get to the point of, right, well, we've given you a reasonable instruction to be mindful of your colleague, and you've failed to comply with that. It's definitely always a good idea to have clear policies and things. And I think what I would say there is that it would be trying to support the whole openness, and if you feel uncomfortable with anything, you know, we want to have an open, and we want to have an open working environment, and we want to have an environment where people feel comfortable to be themselves. But if anyone starts to sort of express their own opinions and views in a way that makes you feel uncomfortable, please make sure you let us know, because what you don't want is a situation where somebody feels really uncomfortable, but they don't feel they can do anything about it until suddenly it's a huge issue, and that's when it moves on to formal grievances and things. So yeah, I think adapting policies and procedures is always a good idea, and also a bit of training as well in what, you know, in the appropriate behavior at work, and when, and you know, when things might tip over from being you know, an interesting internal debate between two people who maybe don't agree with something and who like a bit of a chat, into something that's now getting a bit more aggressive and a bit more personal and inappropriate. So you can get training on things like that, and I think that would also be useful.
That's amazing, thank you. There's been another question come in anonymous. Could you provide a few examples of the kinds of criteria that employers should be considering for redundancies, please?
Okay. Yeah, so this is again, yeah, very, very topical. We've definitely been covering this lately, and it's difficult, I think. Obviously, the best criteria are objective criteria, but often objective criteria are things like sickness absence. Do you have any disciplinaries? Your length of service, although you need to be a bit careful with that one. But they don't necessarily measure the skills that you want to retain, because if you're trying to retain, if you're going to go from 10 people doing something to 7 people doing something, you need to make sure you retain the right 7. So you do end up needing to have some criteria that measures skills, and that starts to get a little bit more subjective. Now, a good thing is to make sure you have regular appraisals and things, because if people have a score in an appraisal, you can use that to score them. And that's always quite helpful, especially if they've agreed with that score at the time. It's difficult for them to disagree with it. But also something that I find really useful to make a more subjective criteria a bit more objective is your actual scoring. Now, I think often people think of, right, I have to make sure that we have this good criteria. But what's often just as useful and just as kind of crucial is how you score it. So if you say that we're going to score somebody on, you know, skills in their work, and you say, right, the way we're going to score them is 5 is excellent, 4 is very good, 3 is good, etc. That's kind of not really any use to anyone, because who decided what excellent was? And if you've got 2 different line managers assessing people, you might have very different ideas of, well, what does excellent mean? So what's a really good idea is to come up with a really objective scoring system. So an example might be something like has demonstrated good knowledge and use of all of our operating systems. And then that might be 5 points. And then 4 points might be has demonstrated good use of approximately 80% of our operating system, something like that, where you can then go back and you can use the work that they've done to show, right, well, you haven't been able to demonstrate this. So I would say that the scoring is definitely just as useful as the criteria potentially when actually looking at that. The other point actually that I was just about to forget to mention is a really good thing to do is weight it. So you can weight the scoring, because then it means you can bring in your really easily objective criteria like sickness absence, but you might be, well, we're not actually that bothered about sickness absence that much, although do be careful with sickness absence, not using time when someone's been off for something that could be a disability, by the way, just as a little note. So you could have the sickness absence one, but the thing that you really care about is maybe, like we were saying, like the skills that the person has. So then you can weight that. So whereas these can be out of 5, that one can be out of 10. So it means that then you can, they can actually get more of a score on the things that you really you find particularly important. So I hope that's helpful.
Amazing, thank you. And you mentioned sickness there. So the next question is around sickness, coming in from Kate. If an employee has been off sick for over 18 months and is having ongoing treatment with no end in sight for return, at what point could you consider terminating employment and able to have occupational health report due to ongoing physio?
Well, now really, I would definitely say if they've been off for 18 months and there's no end in sight, definitely take advice on that. And I'm going to refer back to our disclaimer here. I don't know the background to this, and I'm certainly not telling you go out and dismiss them. But what I would say is that there isn't a rule as to how long. It's more with the no end in sight issue. So obviously, if someone's been off for a couple of weeks, it's going to be a bit weird to be like, oh, well, there's no end in sight of them coming back. But it's not so much how long they've been off. It's more, is it reasonable for you to think that they're going to be off, for quite a long time going into the future and with no particular end in sight. So anyway, yeah, I would say that that's 18 months would certainly be, it's been a long time that they're off. And if there's no real change, it's maybe reasonable to think that it could be that long going forward. I didn't quite understand your point regarding physio, but I suppose what I'd say is there's been case law to show that if you are going to consider dismissing for ill health, you need to get up-to-date medical reports. So don't rely on a report that you had, 6 months ago, say. If you're considering now, well, we want to move to dismissal, you'd need to go and get another report, get a report that ideally is going to say, yeah, we don't really see any change in this condition. It's unlikely that this is going to change in the next several months, and so we can't really foresee that they're likely to come back to work. An old report saying that, especially if that maybe contradicts what the employee's saying, if the employee's saying to you, but I've started to feel quite a bit better, and you're trying to rely on an old report from months ago, could cause some serious difficulty. Another thing, sometimes these reports aren't very helpful. Ultimately, it is about the employer's interpretation of the situation. So even if, and this is a bit risky though, so definitely take advice, but even if you've got a report saying, well, we think they maybe would be able to come back to work, you're potentially entitled to go, I don't think that they are, because it might be something like, you work in a removal company and that they've got to work with another person, and the safety of the other person relies on them both being really fit. You might potentially be able to go, we can't risk that. And even though the doctors kind of said that, we don't think that they fully grasp, the weights that this person has to lift, the job they have to do. Ultimately, the decision is yours. But, big caveat here, if you're thinking of going against a medical report, that would be, be a difficult thing to do. And I'd probably rather sort of suggest at that point, if they seem to not understand the role, go back and say, look, we really think that you've maybe missed some crucial elements here of what this person has to do at work, and we want you to just consider your position, bearing in mind X, Y, and Z of the things that they have to be doing. I hope that was helpful. I feel I went a little bit off on a tangent, but hopefully that answered your question.
Don't worry, that's amazing. And we are at time. So there were some more questions that came in, Fiona. So just to let everybody know, we will be sending you out an email and we will look at the questions and get those answered for you. So I just want to finish by thanking everybody for joining us today. As Fiona said, we hope you found it useful. A survey will automatically launch after we end this webinar, and we'd really appreciate it if you took the time to please fill it in. We will also be sending out some additional resources along with a recording of the webinar if you do want to watch it again. If you have any specific questions, you can reach out directly to Stephenson Law. We'll include those details on the email. And with that, I just want to say a massive thank you to Fiona. Thank you so much for walking us through that. And I wish you all a wonderful day.
Thanks ever so much.